31, it was fixed on 9th, my lord, and both the parties were asked to file the payment slip of last 1 year, my lord. My lord, we have already filed, my lord, but the other side, and it is today, my lord, if you lords may take this matter.
31.
Yes.
Get the file, call the other side.
Yes.
Call the
Your Ladyship, serial number 70. It is an urgent matter. Demand draft has been submitted, which is going to lapse on 28th of February.
Who has submitted the demand?
The OP number 2.
It's an NI Act.
71st half.
490.
70.
490.
Your Honor, is a
That has to be released.
a part of permanent alimony. Your Lordship.
That has to be released to the opposite party. There is a direction to release.
No, ma'am, for modification.
For modification. Okay, she is ready to accept that.
Yes.
And still she is contesting, or that requires full and final settlement.
It has been finalized, and judgment and decree has been passed.
Okay.
In major levels.
Judgment and decree has been passed by the learned court below. And the amount has been deposited here.
Yes.
Okay. We'll take up the matter. Parties are here.
Petitioner is here.
She is the petitioner.
Yes, sir.
And where is the husband?
Husband has not appeared in this case.
Notice has not gone.
No, ma'am. The case has not been taken up until now.
You see, normally the execution is filed before the learned
Ma'am,
court below.
it was submitted in criminal revision 51 of 2021 in this learned court.
You can. Okay, let us see. Get the records, please. Did the records come?
It was listed today.
Let the records come. It will be taken up today only.
Okay.
Yes. May I mention one case note of first half, serial number 46.
First half we don't.
Serial 46, what has happened in this case?
No, why didn't you mention it in the first half? We can't do anything about it.
उसमें क्या था हम उसमें अपोजिट पार्टी के अंदर अपेयर कर रहे हैं लास्ट ऑर्डर था उसमें कि इनको सरेंडर करना था जिनको ये प्रोविजनल बेल लेकर के एंटरटेन कर रहे थे पिटिशनर neither they have deposited the amount in question under an area nor they have surrendered himself.
Serial number 46 must be under heading for orders.
Yes.
All the orders matters are coming up tomorrow. All the orders matter of the first half, including defective petitions as well as orders.
Tomorrow.
Yes, all these matters are coming up tomorrow. Because there are bail matters also, we have to dispose of the bail matters. There are certain petitions for exemption from surrender. We'll take care of that also.
70 के में तो हमारी first half का ही.
First up. Lady is there, अब बेचारी कहाँ से आए हैं? So that is of the first board of the first half, no?
Yes, sir.
So it should come in this. It come tomorrow. Okay, we shall see the record.
From supplementary list for admission item 1, Criminal Revision 96 of 2022.
The order of maintenance. What in this case, earlier an order of maintenance was passed in favor of the wife, granting 3,000 per month. And thereafter, a modification petition was filed by the husband also and the wife also. By the husband on the ground that there was a criminal case against the husband, the wife had lodged. After conviction in that criminal case, the husband was removed from the job. On that ground, the modification was filed under 127.
Modification saying what that?
For a maintenance order to reduce the amount of.
What was the reduction you were seeking?
Yes.
You were seeking from 3,000. It should come to what?
Come to some lesser amount as at the time.
Some lesser amount you must have assessed, no?
Yes,
that it should be 3 rupees.
No matter. 1,500 to 2,000 about velocity. And at the time of granting maintenance velocity, the entire property and the job of the petitioner was considered by the trial court velocity. Thereafter 3,000 was filed.
Per month.
per month. Thereafter, 127 application was filed saying that at the time of granting maintenance, my job was also considered, but now I have lost the job, so it should be reduced. That was rejected, and a petition by the wife was also filed for enhancing the maintenance amount. That was allowed, and it was enhanced to 3,000 to 5,000.
3,000 to 4,000 perhaps.
4,000 in this order, earlier order I am speaking about.
It has been enhanced to 4,000.
In this imperial order,
Yes.
earlier 3,000 to 500 enhanced.
3,000 to 500.
500. Earlier it was enhanced to 3,000 to 500.
When was it enhanced and where is that order?
Yes, but I'm coming to that point.
No, you just placed the order.
That was challenged before this honorable court, Lordship. Thereafter, that the honorable court remanded it back to the trial court to fresh consideration. I may kindly place the order, Lordship.
Where is that order?
Page number 11.
You are Avnish Kumar,
Avinash Kumar.
Avinash Kumar. This was,
The observation was
just a moment, initial when was the order of maintenance was passed for 3,000 rupees? What is the date of that order?
Yes, ma'am. And 65 in 2006 monthly.
This was in 2006.
Six,
Maintenance case number 65
65
of
of 2006.
06. Then what happened?
Thereafter, it was husband filed application under 127 and wife also filed application under 127.
When did you file that? That's second application was filed when?
That was filed
What was your case number?
2000, case number 6 of 2013. That was filed by the wife.
Case number 6 of
Miscellaneous case number 6 of 2013
13 by wife
by wife. Your
for
Lordship.
enhancement.
Yes, my lord. And yes,
And miscellaneous case number
3 of 14
3 of 14
by the husband under 127.
Okay, both these under 127.
Yes, my lord.
Okay. So she paid for enhancement and he paid for reduction
Yes,
on the ground that he has been convicted.
yes, convicted and lost the job.
This happened in 2014 itself.
Yes, yes, my lord.
All right. Then
Thereafter, Your Lordship, my application was rejected and wife's application was allowed, and it was enhanced to 3,000 to 500.
3,000 was enhanced to 500.
500. 5,000. Sorry.
It was these two cases were disposed of by the order dated
Right. Order
19/9/2015.
Yes, madam.
19/9/2015. It was enhanced to 5,000.
5,000.
Then
Thereafter, the petitioner preferred a revision application.
yes,
9. Yes, madam.
93.
Yeah, 93 of 2016.
2016 for reduction and 1375 of 2015 against enhancement.
Enhancement.
Okay. Then what happened? What happened in this case?
Yes, that was allowed, and the order was remanded back.
On what ground?
Yes, madam. Page number 13 mechanism. Para 7. The learned principal judge family court Lohardaga has referred to the judgment in so and so. However, there is no consideration by the learned family court judge regarding the effect of dismissal of the application from service, which definitely would have reduced his income. There is no discussion on merits of the plea taken by the applicant in Muslim case number 3 of 14. In my opinion, for granting an order of enhancement of the monthly maintenance amount also, the learned family court judge was required to discuss this aspect of matter, Your Lordship.
All right. For fresh
Yes.
consideration
Yes, for
on the
Christmas-
basis of materials already.
already on record, Your Lordship.
Then what happened?
And on the same date, Your Lordship, the conviction of the petitioner was also set aside and he was acquitted. In another revision application that has been annexed.
So you were taken back in job.
Yes, sir.
You were
Yes,
taken back.
he had applied for, but current instruction I am
The
I
current
cannot
instruction
appreciate
we are
whether
not-
he has been
Yeah,
appointed or not.
Their criminal revision was also
Allowed,
allowed.
and he was.
This is
Yes, this aspect will come. He may be appointed again, Your Lordship. This may come. Your Lordship.
15. This happened on 23/7/2021. Conviction was set aside.
Yes, ma'am.
Then what happened?
Thereafter,
This happened in 2021.
yes.
So you don't have instructions also.
No, currently, Your Lordship, 2, 3, 4 months before, Your Lordship, I had heard from the concerned lawyer, Your Lordship, that he will process that he will be reappointed in the service.
Very good. Then what happened? Just please hold on. Yes.
Yes, ma'am. Thereafter, this impugned order was passed, Your Lordship.
Pursuant to the order of remand.
Yes. That has been challenged before, Your Lordship.
What is the amount of
4,000 now at least.
Suppose you were unemployed. What would be the amount of maintenance?
But my consideration was only at that time. And,
No, that is, you
yes,
see, way back
yes,
in
yes.
2000, there is a lapse of time also, no?
Yes, ma'am. For that I will not have.
So 4,000 is, even as per minimum wages, you are not a crippled person, right? You have your good health. So in Neha versus Rajneesh, it has been taken care of. That even if a person is unemployed, then also maintenance is required to be granted. That's it. You want to say anything?
Yes, Your Ladyship. As per my information, her husband is employed to BSF again, and I have.
He was in BSF.
He was.
So you go and file enhancement.
Your Ladyship, I am praying for filing counter again.
Nothing is required. You see, we will only see the impugned order. We cannot enhance it. It is not your petition. If you want enhancement, you have to file again a petition under section 126.
Maintenance भी नहीं मिलता है.
मिलेगा उसके लिए एग्जीक्यूशन के लिए इनको जेल भेज दीजिए फिर से ये फिर से डिसमिस हो जाएंगे you know
2000.
there is a provision for sending a person to jail, so you file your execution. This time you will not take the risk. Why don't you pay her? As it is, you'll have to pay.
No, he was paying at that time also when I was arguing that matter. He
You
was
can
paying.
ask the court to attach his bank account.
He
Or
was
you can
paying
ask
also.
the employer to remit the amount to your bank account.
If currently
Right.
she is not receiving anything, I am not able, but he was paying.
So you must be running after her. Please take the money.
Yes, ma'am.
This for 3,000 rupees, yeah. Some cost should also be given to her.
That was considered earlier also.
Cost.
That was the
Cost for coming to the court.
no, Your Lordship, that has been allowed. That has been accepted by the honourable court also, Your Lordship. That has been allowed. That has been considered by this honourable court only, Your Lordship. Because I didn't come in a routine manner, Your Lordship. After dismissal of job, I came to the honourable court, Your Lordship. In routine manner, as there is a maintenance
Liquid debt.
order, I will come to the
Criminal
court.
Revision number 96 of 2022. This petition has been filed for the following relief. The learned counsel for the petitioner, while giving the background of the case, has submitted that the relationship of husband and wife is not in dispute.
Yeah, they are legally married.
The relationship of husband and wife between the petitioner and opposite party number 2 is not in dispute. The opposite party number 2 had filed a maintenance case before the competent court, being OMC number 65 of 2006, and was allowed a maintenance of rupees 3,000 per month. Thereafter, the opposite party number 2 filed a petition under section 127 of CRPC, bearing miscellaneous case number 6 of 2013 for enhancement of maintenance from rupees 3,000 to rupees 10,000. At the same time, the petitioner also filed a miscellaneous case number 3 of 2014 under section 127 of CRPC for reduction of maintenance on account of his dismissal from job. The learned counsel submits that at the time of filing the application under section 127, the petitioner stood convicted and therefore he was dismissed from service. However, in the year by judgment dated 23rd July 2021, passed in criminal revision number 92 of 2015, the order of conviction of the petitioner has been set aside. The learned counsel has also submitted that the petitioner was earlier working in BSF, and he is not aware as to whether the petitioner has been ultimately taken back in service order. The learned counsel further submits that by common order dated 19/9/2015, the miscellaneous case number 6 of 2013 filed by the aforesaid miscellaneous case number 6 of 2013 and miscellaneous case number 3 of 2014 was decided, and the amount of maintenance was enhanced from rupees 3,000 to rupees 4,000 to rupees 5,000. Thereafter, the petitioner filed criminal revision number 93 of 2016 against the order dated 19/9/2015, passed in miscellaneous case number 3 of 2014, and also preferred a criminal revision number 1375 of 2015 against the judgment dated 19/9/2015, passed in miscellaneous case number 6 of 2013. And ultimately, the order was set aside. The common order dated 19/9/2015, passed in miscellaneous case number 6 of 2013 and miscellaneous case number 3 of 2014, was set aside by this court by judgment dated 23rd July 2021, passed in criminal revision number 93 of 2016 and criminal revision number 1375 of 2015, and a fresh order has been passed pursuant to the order of demand. While referring to the order dated 23rd July 2021, passed in criminal revision number 93 of 2016 and criminal revision number 1375 of 2015, the learned counsel has submitted that this court has taken into consideration that once the petitioner was out of employment, then there was a necessity for the learned court below to consider this aspect of the matter, as the same would have had a bearing on his income. The learned counsel has referred to the fresh impugned order, fresh order which is impugned in the present case, and submits that as of now the amount of maintenance has been enhanced from rupees 3,000 to rupees 4,000. The learned counsel appearing on behalf of the opposite party, on the other hand, has submitted that though no counter affidavit has been filed in the present case, but as per her instruction, the petitioner has been taken back in service. The learned counsel has further submitted that even if it is assumed that the petitioner was unemployed, then also 4,000 rupees is a meager amount, and in view of the judgment passed by the Honorable Supreme Court in the case of Neha versus Rajneesh, there is a clear mandate that even an unemployed, able-bodied husband is required to maintain his wife. The Learned Counsel submits that, considering the amount of maintenance fixed by the Learned Code below, the impugned order does not call for interference under judicial jurisdiction of this court. She has also submitted that the maintenance of rupees 3,000 was fixed way back as in maintenance case number 65 of 2006, and much time has elapsed, and at that point of time the property of the petitioner was also taken into consideration. Yeah. Is that correct?
Yes, ma'am.
The property of the petitioner was also taken into consideration?
Yes.
Yes. After hearing the Learned Counsel for the parties and considering and after going through the impugned order passed in this case, this court finds that an amount of maintenance was fixed as in the year 2006 by maintenance case number 65 of 2006, amounting to rupees 3,000 per month, and the enhancement of the maintenance amount is only by 1,000 rupees by the impugned order dated 7/12/2021. And as per the impugned order, the enhanced amount has been directed to be paid from the date of the impugned order. Is that correct? From the date of the impugned order. In the judgment passed, इसको भी- although the conviction of the petitioner, which was the reason for his dismissal, has been set aside, it is further not in dispute from the side of the petitioner that the order of conviction of the petitioner, which was the reason of his dismissal from service, has already been set aside. In the judgment passed by the Honorable Supreme Court, reported in case of Rajneesh versus Neha, reported in bracket 2021, bracket close 2 SSC 324, it has been held in paragraph I'm just not getting that back. There is a specific paragraph in this judgment, I remember. It has been held in paragraph such as dash. I'll just find out that paragraph and put it. that even in case of, even in circumstances where the husband is unemployed, that is not a ground for denial of maintenance. This court finds that the learned court below, while granting enhancement of maintenance from rupees 3,000 to 4,000, has assigned the following reasons, page number 31, sir, under such observation, right? And has rejected the prayer of alteration of maintenance made by the petitioner on ground of his removal from service, and has held that the same cannot be a ground considering the due weight in the light of his age and possession of proper health and having agricultural land as well. This court finds that the learned court below has passed a well-reasoned order, and the enhancement of maintenance is only a meager amount. This court finds no reason, no illegality or perversity in the impugned order. Accordingly, this division is dismissed.
Item 2, Criminal Division 821 of 2022.
In this case, the petitioner has come with the main division of the arbitration of, but that was during the pregnancy of this application, I have filed IA.
For what?
On 12/1/24, the learned court below has filed pass an order to pay the arrears about 9 lakhs. On current maintenance, I am paying 21,500.
Arrears also you'll have to pay.
I have, but now they are having mediation in the matrimonial divorce. That I have also annexed it. It says that the condition is that again the divorce suit and the criminal cases which have been filed by the wife will be withdrawn. Then we will live together. They will come. The conditions are there. I have annexed that. On that ground, I am praying.
Where is that condition?
And that is an extra IA to.
Yeah, for the wife.
Yes, but we have to file a counter for this IL lordship. Let's say they are not fulfilling the conditions of this compromise lordship.
So you are not agreeable to this now.
Yes, lordship.
Has any amount been paid to you so far?
Yeah, current amount I am paying.
The current amount you might be paying, but is there any permanent alimony fixed?
No.
This was in the matrimonial suit.
Yes.
ये
Original matrimonial suit.
25 को mediation हुआ है मतलब legislation में
Original
उसी
suit number 87/21 में इसका लेता resolution से लेता 31 13.
She doesn't want to take back the matrimonial case.
I am ready to keep.
We are not here to enforce the compromise.
On 25/1/24 they have come in the compromise.
She is living with you.
I am ready to take her.
Ready to
I am ready to take her. It was mediation was done there on the last occasion also.
She doesn't want to go.
No, she wants, but her mother is objecting to that.
That's
That is the fact.
it's for you to decide. It's for her to decide whether she will listen to her mother or she will listen to her husband.
That's the problem.
You have not made enough effort to bring her.
I'm still ready to keep her.
We will not interfere with this. We are only concerned with the impugned order. We are not concerned with your arrears or whatever. What is the impugned order? Let us see.
This,
We'll argue the case on the basis of impugned order. We are not going to entertain on this. Yes.
impugned order is at page.
You are seeking alteration and there is no.
That alteration was filed in the court below. that was rejected. Against that we have come, and the original order which was passed in maintenance case, I have filed IA for to add prayer.
No,
on-
you can't add prayer like this. We will see only the impugned order. In one revision, one impugned order, nothing more. There was no change, and you filed an application for modification. So that has been dismissed.
At that time I was getting salary of 25,000 and 21,500.
No, show it from the impugned order, please.
Yes, yes.
The impugned order says that there was no change circumstances.
That it says, but fact is that the
No, not fact. What was the material before the learned court below for
I
consideration of your change of
I
maintenance?
filed the reply to that they have filed it.
No,
which I have
this-
annexed it.
The present application which has been impugned, with the order passed in the application which has been impugned was filed by you.
Yes.
So what was your ground?
Ground was that at that time I was getting 25,000.
When were you getting 25,000?
I have filed the application annexed as an extra 2 in the main at page 20. At paragraph 4 I have stated that opposite party had submitted his payslip which showed several deductions from his salary which included advance loan taken as well as income tax deduction which comes to rupees 20,100 and the opposite party gets 25,814.96 paisa by only by way of salary. And paragraph 5 is
No, I am not able to get what you are saying. You place your petition. You see, by the order dated 26/11/2021,
yes,
right?
Yes.
The maintenance was fixed at rupees 11,500
and 5,000 each to the
each
minor
for
daughter.
2 minor daughters, right?
Total 21,500.
So this order was challenged by you.
Yes,
26/11/21.
Yes, not here. I have filed under section 127 CR in the court below itself.
So that order has become final. Now you have to show some subsequent development after order dated 26/11/20.
Subsequent development is that
You are trying to seek review from the learned court below. No, that is not permissible.
127 says
No, that is not review. That is, that is enhancement or reduction of
Yes,
maintenance.
that-
That is
for
not a
deduction-
review of the order.
deduction. I prayed
Reduction
at
for
that time.
reduction, you have to show subsequent development.
Yes, that
What is the subsequent development after this order? 26/11/2021.
subsequent development is that there was a mediation. She agreed to that,
No.
and
That is
everything-
not the situation so far as the impugned order is concerned. Mediation, etc., that is a separate thing. We will not entertain that. We will only see the impugned order. You are seeking a review before the learned court. We can't do anything about it. Learned counsel for the parties are present. This petition has been filed. For the following relief, court कर दीजिए. The learned counsel for the petitioner has submitted that the petitioner had filed a petition for modification of final order passed in maintenance case number 50 of 2018 dated 26/11/2021, whereby the opposite part whereby the petitioner was directed to pay rupees 11,500 per month to his wife and rupees 5,000 per month to each of 2 minor daughters. The learned counsel submits that the petitioner is paying the current maintenance, but so far as arrears is concerned, that has not been paid. However, by referring to the impugned order, the learned counsel has submitted that the maintenance which was fixed on 26/11/2021 was on much higher side, And in terms of section 127 of CRPC, the petition for modification of the maintenance amount was maintainable. The learned counsel appearing on behalf of the opposite party while opposing the prayer has stated that section 127 CRPC makes a provision for enhancement or reduction of maintenance which may occur on account of subsequent development after the passing of the order. And section 127 does not entitle any party to seek review of the order. He has also submitted that review of order passed under review of order is not maintainable in matters covered by CRPC. The learned counsel has further submitted that the order dated 26/11/2021 fixing the maintenance was never challenged by the petitioner before this court. Is that correct?
Yes.
After hearing the learned counsel for the parties and considering the facts and circumstances of this case and upon perusal of the impugned order, this court finds that the maintenance was fixed in original maintenance case number 50 of 2018 for the wife and 2 minor children of the petitioner. The order was passed on 26/11/2021. Admittedly, the order dated 26/11/2021 was not challenged by the petitioner before this court, and the petitioner instead, the petitioner filed a petition before the learned court below seeking alteration in the maintenance amount, which was numbered as maintenance alteration case number 1 of 2022. The learned court below has considered the provisions of section 127 of CRPC and has recorded that such provision is applicable only when there is a changed circumstances. There is no question of review of any order which has been passed by the court under section 125 CRPC. The learned court has also recorded that there was not even a single word stating regarding any medical expenses or any serious disease of the petitioner, and that the documents which were filed with the alteration application were dating back to the year 2019 and thereafter. The learned court below has also recorded that in the alteration case, no changed circumstances were shown, and rather the alteration case was filed, rather it was a case seeking review of the order of maintenance in the garb of alteration case. The learned court below recorded that there was no change in circumstances and therefore rejected the alteration case. After having gone through the impugned order and the arguments of the parties, this court finds no error in the impugned order, no alternative, no change of circumstances has been shown by the petitioner during the course of argument. With regard to the filing of maintenance alteration case number 1 of 2022, it has been simply stated by the petitioner that there has been a compromise between the parties
In mediation.
in mediation. This court is of the considered view that so far as compromise between the parties is concerned, it is for the parties to take appropriate steps for purposes of filing joint compromise petition in the various cases. And so far as the impugned order dated 2/7/2022 is concerned, the same does not call for any interference, as this court finds no illegality or perversity in the same. Accordingly, this petition is dismissed.
From Kerala for admission item 1, Criminal Division 198 of 2022.
May permitted to draw this petition, matter has been settled between the parties.
Criminal Division number 198 of 2022. This petition has been filed for the following reason. The learned counsel for the petitioner, Mr. Sanjay Kumar Pandey, seeks permission to withdraw this petition. Permission is accorded. This petition is dismissed as withdrawn.
साइन कर दिया था.
Item 2, Criminal Division 309 of 2022.
Permission to withdraw the case.
Criminal Division number 309 of 2022. MS. Your name, please.
Sonali Bhattacharya.
Sonali Bhattacharya. Under the instructions of Mr.
Kalyan.
Mr. Kalyan Roy. Kalyan Roy is not there on record. Mr. Siddharth Roy. Siddharth Roy, advocate on record, seeks permission to withdraw this.
With liberty.
No liberty can be granted. Seeks permission to withdraw this petition. You are for?
OB 2 to 4 year lodge.
Any objection?
No year lodge.
The learned counsel appearing on behalf of opposite party number 224 has no objection to the prayer made. Accordingly, this petition is dismissed as withdrawn.
साइन कर दीजिएगा मैडम.
Item 3, Criminal Division 1374 of 2022, along with item 4.
Yes, petitioner.
Your Lordship, in Criminal Division 1374, I am for the petitioner, Your Lordship. And in Criminal
1374.
Yes, Your Lordship.
You are for the wife or husband?
I am for the husband, Your Lordship.
Husband. You are for the wife?
Yes, I have also petition.
Yes. You are for enhancement?
No,
No, Your Lordship.
because there are two child and wife. Two child is the 11 year and 9 years, and there's study in the DAV school, and total education expenses only school fees is 15,000, and maintenance allowed only 12,000, only for the children up to the date of the majority. After majority, there will be no maintenance. That's why I am here. What about the wife? And wife, what will go? Where will go? This ladies.
So you have come for enhancement basically.
No, this is not enhancement, Lordship.
Why have you filed your petition?
Because order should be clear categorically what amount for the children and what amount for the wife.
This is
And
a
after-
consolidated amount.
Yes, Lordship. And after the date of the majority, whether wife will get or not, this is the question.
So when the children become major, you move an appropriate application.
That is, हमको कुछ मिल ही नहीं रहा है, हम एप्लीकेशन के ऊपर एप्लीकेशन कैसे कर सकते
Your
हैं?
Lordship, in
ये तो
regular bail, the petitioner had appeared before the lower court, and in the regular bail, he was directed to pay rupees 8,000 per month, Your Lordship. And before the order of this original maintenance case also, Your Lordship, he is continuously paying rupees 8,000 per month. Till date, he is paying rupees 8,000 per month, Your Lordship.
You see, there is a direction to with effect from this per month. What is their present age?
present age 11 years and 9 years.
Appropriate petition you move at that relevant point of time.
Lordship, so far his
Because we do not know, you see, we do not know that what will be the, maybe that the court might ask that you continue to pay 8,000 rupees after 5 years, 6 years. Isn't it?
इस ऑर्डर में अगर आ जाता है लॉर्डशिप कि हम एप्रोप्रिएट पिटीशन फाइल करेंगे वो चीज आ जाएगी
At the appropriate time, when they are about to gain their majority, you can file an appropriate petition so that the amount can be fixed.
And one more text, lordship, here our petitioners already said at the time of the bail petition 8,000 given. So far I am my counter affidavit para number 4.
No, we will come to that. Let us hear it first. Your matter is over now. Okay. Let's hear it. Yes.
Lordship, petitioner, as per claimed by the respondent, your lordship, opposite party, that he is having two luxurious vehicles, your lordship, and out of that, he is only having one duster car, your lordship, which he has purchased second hand, and the other luxurious vehicle was just a two-wheeler, your lordship, which is a classic bullet, your lordship, and they are telling that 30,000 rupees per month from the car rent he earns, and 1 lakh from his business.
No, you just 8,000 rupees for 3 persons.
Your lordship, he is paying.
It is the minimum possible.
Your lordship is continuously paying that amount till date he is paying, and from the date of before the order of the maintenance.
12,000 rupees per month.
Yes, it was decided in the maintenance case, your lordship. Prior to that, also he was continuously paying 8,000 rupees, your lordship. He is also not.
So additional 4,000 only.
Your lordship, he is not in a state of position to transfer 12,000 per month, your lordship.
12,000 per month minimum wages. You know what is the minimum wages in Jharkhand?
Yes, your lordship.
It is much more than this.
Yes, your lordship.
So,
your lordship.
Even if you are unemployed, you are supposed to pay this amount.
Yes, your lordship. He is ready to pay the amount.
So how do you question the quantum of maintenance? Because it is clearly stating that he is already receiving. That will be deducted and adjusted. He has taken care of that.
Yes, your lordship.
Then, marriage is not in dispute.
No, your lordship.
Children are not in
No,
dispute.
your lordship.
They are studying. That is also not in
Yes,
dispute.
your lordship.
That's it. Right?
Lordship, my awardment, Lordship, para number 11. The students.
No, we are not with him. We are not going to interfere.
Yeah, that's true. Lordship, my counter 11 para 11. Total education expenses is 15,951 per month. So he is free to pay directly either school.
No documents were produced, your lordship, in the trial court, your lordship.
लॉर्डशिप मैंने बेल पिटीशन के समय ही सारा डॉक्यूमेंट्स लगाया था मेरे पास उतना पैसा नहीं है कि मैं कोर्ट
You will get legal aid, don't worry. You want legal aid?
But it has not
We
been
will give you
decided
legal
in the
aid.
trial court, your lordship, in the intense petition.
yes lordship rather
You see, you have not come for enhancement of maintenance.
yes
That is not your case. You have not come for enhancement.
I'm not on this point.
So when you have not come for enhancement, then how cannot we pass an order for enhancement? We are not interfering with the order, whatever has been fixed.
Yes.
Right?
But
if you have any expenses, then you can-
on more thing, Lordship. Only one thing, one point, Lordship. May I appreciate regarding he told 8,000 per month bank account number such and such every month paid on the basis of the BA number 763 2019. And he is telling in his petition and ground taken, Honorable High Court says 8,000. Now how can he enhance?
No, we are not touching upon it at all. Okay, we are not interfering with the order.
Yes.
That is it.
Lordship, in the meantime हम enhancement के लिए application दे सकते हैं?
I am not your advisor. लिखिए. Criminal revision number 1374 of 2022 with criminal revision number 1324 of 2022. Both these petitions have been filed against order dated 19/10/2022 passed by learned Principal Judge Family Court Bokaro in original maintenance case number 58 of 2022 passed under section 125 of CRPC. The learned court has directed the petitioner in criminal revision number 1374 of 2022 to pay rupees 12,000 per month jointly for maintenance of wife and 2 minor children with effect from 27/2/2020 within bracket date of filing the case bracket close, and has also observed that maintenance of rupees 8,000 per month, which is being already received by the wife, shall be deducted/adjusted. So far as criminal revision number 1324 of 2022 is concerned, the same has been filed by the wife and the 2 children, and the only grievance as is apparent from the revision petition is that the amount of maintenance has been jointly fixed for 2 children and wife, and the children have been held to be entitled to get their maintenance allowance till their majority. The counsel for the petitioner has submitted that the manner the petitioner is, the counsel for the petitioner in criminal revision number 1324 of 2022 has submitted that the petitioners of the said case are aggrieved by the manner in which the order of maintenance has been fixed, that is jointly for the wife and 2 children, and once the children would become major, then there will be a problem with regard to maintenance of the wife, and therefore the order of maintenance of children and wife is required to be segregated.
Yes.
The learned counsel for the petitioner in criminal revision number 1374 of 2022, while assailing the impugned order, has submitted that there was an order passed by this court in BA number in BA number
In BA number 5763 of 2019, Your Lordship.
in BA number 5763 of 2019,
Yes, Your Lordship.
directing the petitioner to pay maintenance of rupees 8,000 to the wife,
Yes.
the order in the bail application was passed on
3/2/2020, Your Lordship.
3/2/2020
Yes, Your Lordship.
and submits that once the maintenance amount was directed to be paid in the bail application, there was no occasion to
Maintenance
fix
amount,
the maintenance amount at the rate of rupees 12,000 per month.
Lordship maintenance नहीं था वो compensation. Compensation.
The learned counsel has submitted that accordingly the impugned order calls for interference. That is your case?
Yes.
The learned counsel appearing on behalf of the opposite party has submitted that the order passed in the bail application was only by way of compensation and the same cannot be said to be an order of maintenance. Where is the bail order? Not annexed. A copy of the bail order has not been annexed in the records of this case. After hearing the learned counsel for the parties and after going through the impugned order dated 19th October 2022, this court finds that the marriage between the petitioner and the opposite party number 2 is not in dispute, and it is further not in dispute that opposite party number 3 and 4 are minor children of the petitioner and opposite party number 2. The case of the applicant before the learned court below was that the marriage was solemnized on 22/10/2010. Oh, sorry, 22/10/2008, and after marriage, the family members of the petitioner started demanding dowry, and due to which she was subject to cruelty, and on 5/11/2017 she was confined in room for 3 days and no food was provided to her, and in order to defame her, indecent video was prepared and a threatening was given that the video would be made viral through mobile. When her parents came to know about it, they had taken her back, and ultimately a criminal case being BTPS case number 49 of 2019 under section 498A, 324, 313, 34 and 3/4 of Dowry Prohibition Act, as well as section 67 of
67A.
67A of
Information Technology Act.
capital A.
Yes.
67 capital A of Information Technology Act was lodged. And at the stage of granting bail by this court, there was a direction to pay rupees 8,000 per month towards educational expenses of the children. It was the case of the applicant that the petitioner, being instigated by his parents, got the name of their son struck off from the school, and the applicant had no source of income. It was her further case that the petitioner is a businessman who earned rupees 1 lakh per month, besides income of rupees 30,000 per month from car rent, and a prayer was made seeking maintenance of rupees 75,000 per month. A show cause was filed by the petitioner, and his specific case was, he denied the allegation, and his specific case was that he was having a stationery shop and hardly earned rupees 15,000 per month. And out of his earning, he was paying rupees 8,000 per month in the bank account of the petitioner as directed by this court. When was this order passed?
Day of
19/10/22. See, pursuant to the order of the Supreme Court, there was no affidavits filed regarding disclosure of income.
Yes, no words. On that time, there is no.
They will not sustain this order. They will not sustain this order in this manner. Because there is a huge gap between what she claims and what has been granted.
Lordship, no documentary evidence has also not been adduced by the party lordship. And even I have enclosed all the documents, Your Lordship.
Lordship, remand back कर दीजिए Lordship.
This has to be remanded.
Yes. And sir.
This cannot sustain. The maintenance which has been fixed, you'll have to continue to pay
Yes, Your Lordship.
subject to final outcome. I'll fix a date for appearance of both the parties.
And so far the segregation is concerned, also will look after.
This order can't be sustained. You take down again. You take down again. Criminal revision number 1374 of 2022 with criminal revision number 1324 of 2022. Both these petitions have been filed against the judgment dated 19th October 2022 passed by the learned court below. The learned family court at the learned principal judge, family court Bokaro, whereby the maintenance has been fixed at the rate of rupees 12,000 per month for the wife and 2 children, and a further direction has been made that an amount of rupees 8,000 per month, which was already being received by the wife pursuant to order of bail passed by this court in the criminal case under section 498A and other analogous cases, be deducted from the maintenance amount. The effective date of grant of maintenance has been fixed from 27/2/2020. The counsel for the petitioner, husband, the counsel for the husband who is petitioner in criminal revision number 1374 of 2022 has submitted that the quantum of maintenance was rupees 8,000 per month was already directed to be paid by this court in the by granting bail to the petitioner, and there was no occasion to fix additional amount of maintenance. The learned counsel has also submitted that the petitioner had raised a specific plea before the learned court below that he had a stationery shop from which he earns rupees 15,000 per month, and out of that earning he was already paying rupees 8,000 per month in the bank account of the wife. It was also asserted that the wife is a graduate and well capable to maintain the children. The learned counsel submits that these aspects of the matter have not been properly considered by the learned court below. The learned family court, and therefore the impugned order calls for interference. That's it. The learned counsel appearing on behalf of the wife.
Regarding the car rent, Your Lordship.
Okay, the learned counsel has also submitted that so far as rent of car is concerned,
Rupees 30,000.
of rupees 30,000 as claimed by the wife,
Yes.
that was also not substantiated by any
Evidence,
evidence.
Your Lordship. And the car which has been purchased, it was a second-hand car.
And
Your
the
Lordship.
car was only a second-hand car
Up to
and which
10,000.
did not yield any income as claimed by the wife. The learned counsel appearing on behalf of the wife and two children who has filed a separate petition being criminal revision number 1324 of 2022 has submitted that the manner in which the maintenance has been fixed by the learned family court is not in accordance with law. The learned family court has clubbed the maintenance amount for two children and wife by the impugned order. He has also submitted that both the children are studying in the school and the husband is free to pay the school annual admission fee, etc. So far as the children are concerned, directly to the school. The learned counsel has submitted that much more expenses are involved in the matter of the education of two children.
Approx 15,000 per month.
And the expenses is around 15,000 per month so far as the children is concerned.
Both children.
Both children are concerned.
Yes.
The learned counsel has also submitted that the order passed in the bail order by this court does not quantify the maintenance amount, and therefore the fixation of rupees 8,000 in the bail order per month in the bail order has no bearing in the matter. That's it. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the marriage between the parties is not in dispute. It is further not in dispute that out of wedlock, two children were born. It is further not in dispute that a criminal case was filed by the wife for alleged offence under section 498A, 32, 313, 34 IPC and 3/4 of Dowry Prohibition Act, as well as under the provisions of Information Technology Act. It further transpires from the records of this case that an order that the husband was granted bail by this court upon a condition that he would be paying rupees 8,000 per month in the bank account of the wife for the purposes of education of the children. However, a copy of the bail order has not been placed on record, but the same has been duly discussed by the learned court below while passing the impugned order. This court finds that the wife claimed that she was not in a position to maintain herself and she had no source of income. And she had also claimed that the husband was a businessman who earned rupees 1 lakh per month. And besides that, he had an income of rupees 30,000 per month from car rent. And a prayer was made for payment of maintenance at the rate of rupees 75,000 per month for her maintenance and maintenance of two children. On the other hand, the husband had disputed the claim of the wife so far as the maintenance is concerned, and it was his case that the wife was graduate and well capable of maintaining the children, and that he had only rupees 15,000 per month as income, out of which he was already paying rupees 8,000 per month in the bank account of the wife. Thus, apparently, there was a serious dispute in connection with the actual income of the husband.
And
in
impute order, not Rajneesh versus someone.
this court finds that the learned court below has, while passing the impugned order, has considered the judgment passed by the Honorable Supreme Court in the case of Rajneesh versus Neha, reported in 2020 SCC online, वो जो हम लोग citation देते हैं उसी में डालिए, reported in
पास नहीं किया
bracket 2021 2 SCC 324. However, from the perusal of the impugned order, it appears that the required affidavit in terms of the judgment passed in the case of Rajneesh versus Neha with regard to disclosure of income in terms of enclosure 1, 2 and 3 of the state judgment has not been complied by the parties. Although in the case of Rajneesh versus Neha, there was a clear direction that in all the petitions relating to maintenance, even those which were pending on the date of the judgment, the required affidavit was required to be filed. In view of the aforesaid facts and circumstances, this court is of the considered view that the quantum of maintenance has not been fixed in accordance with law, particularly there has been violation of the direction issued by the Honorable Supreme Court in the case of Rajneesh versus Neha Supra. Accordingly, the amount of compensation is required to be the amount of maintenance is required to be refixed, and therefore the matter is required to be remanded to the learned court below. In order to enable the learned court below to pass a fresh order of maintenance, the impugned order is hereby set aside and parties are directed to appear before the learned court below. I'll give a date and a time frame. Right? When will you be appearing? Both of you, tell us.
Any
4th of March? 4th of March 2022.
Meanwhile, 8,000 will continue.
Just, yes. However, considering the fact that the learned court below has fixed maintenance amount of rupees 12,000 per month, which includes the maintenance amount of rupees 8,000 already directed by the by this court in bail order granted to the husband. This court is of the considered view that the husband would continue to pay the maintenance to the to the wife and children. In terms of the impugned order, of course, the same would be subject to the final result of the case, subject to final order which may be passed by the learned Principal Judge Family Court, Bokaro, pursuant to order passed by this court. The parties are directed to appear on 4th of March 2024 along with their affidavits of disclosure in terms of the judgment passed by the Honorable Supreme Court in the case of Rajneesh versus Neha, and fresh order be passed within a period of 2 months from the date of communication of this, within a period of 2 months from 4th of March 2024, the materials which have already been placed on record before the learned court below will also be taken into consideration while passing the fresh order. Counsel for the state is present. You are ornamental. come after the dictation of the order. You have more responsibility.
Yeah.
For female and children, you have more responsibility, isn't it?
Much of my friends.
Item 5, WPS 2834 of 2023.
Yes, petitioner.
Thus, the matter relates to pay fixation of the readers. Thus, before opening the brief, I must say that the counter affidavit has already been filed in this case.
You want to
But
file
my
counter?
respectful submission to the extent is that that there has to be a para-wise reply, because the counter affidavit filed by the state is absolutely vague. And why I am submitting, because I am seeking a pay fixation on the basis of the UGC.
State you file paravise reply.
Plus the
Without
university.
that it can't be.
I am for the university, I have given my reply.
You have
The
given paravise reply?
University has filed the reply. University is supporting the contention of these writ petitions.
The learned counsel for the parties are present. The counsel for the petitioner has submitted that though a counter affidavit has been filed by the state, but paravise reply has not been given, which will be an impediment in proper adjudication of the present case. Counsel for the state is directed to seek instructions and file a supplementary counter affidavit giving paravise reply to the writ petition. Any supplementary affidavit?
No, no, sir.
To the writ petition. The supplementary counter affidavit be filed by 4th of March. The rejoinder, if any, by 11th March. Post this case on 19th of March. 19th. 19th would be a Tuesday.
That's fine.
Okay. 19th March. In the parties to file their synopsis, list of dates and the judgments which is seek to rely upon. The counsel for the petitioner Upar Likhega has submitted that so far as the university is concerned, as per the counter affidavit, they are supporting the case of the petitioner.
The whole case is based on the
UGC pay scale.
UGC pay scale, and our recommendation sent to the state government that this is the pay scale that should be given.
That's
We are standing by our stand.
Let's
Item 6, WPS 3077 of 2023.
These are basically, these, when I see the last order, then I can, I have a, some kind of video that I can figure out what happened in the court. So this is basically for my reminder. The moment I see this order, it will reflect everything.
Because while preparing short notes even helps us a lot events.
Yes. So that is why these short orders are also important. Yes, please. Who is for the
Item 6.
petitioner? Counter 5.
The counter has not been filed. 3 weeks further time it is valid for that.
Further time. There was already an order.
There was 4 weeks time had been granted to file counter. We are yet to receive it.
WBS number 3077 of 2023. Counsel for the petitioner is absent. Counsel for the respondents is directed to comply the order praised for and is granted time till 4th of March 2024 to comply the order dated 5th of January 2024. Post this case on 6th of March. It is fresh filing. Admission.
For hearing item 7, Criminal Division 17 of 2022.
Yes, petition.
At present, both the parties are compromised and living together.
If I join compromise petition, then we'll see.
I have no instruction regarding that.
The husband has came in present in the courts. He tell that they are living together.
Both of you come from outside. I've never seen you. You're practicing here?
Yes.
Sorry.
Old High Court I have appeared.
Must have. I'm sorry. I don't remember. And you?
I'm a regular.
Something is wrong with me only.
I'm severe. I'm assisting.
Okay. All right. So what is it?
The petitioner convicted
Under section 498A
498A for
and?
2 years and under section 4 Dowry Prohibition Act for 6 months.
Section
And
4.
Section 4. And earlier there he remained in custody for 1 year. and thereafter came out on.
You don't have any instructions?
No, I'm not having any instruction regarding the compromise. Till now,
If they are living with
No,
their.
then you have to file joint compromise. Merely because you are living is not sufficient.
Yes, fine.
Merely because you are living together is not
Yes.
sufficient.
Since 2 years last, we are living together.
We do not know.
Husband present in the told.
Merely husband is present.
Huh?
How can
Okay,
it be
I
decided?
just you have the phone number of your client, I suppose.
I will take.
You talk to her, right? I'm posting it tomorrow. If that be so, I'll send it for mediation. Right? Counsel for the petitioner submits that.
If they are residing for since 2 years,
We do
then
not.
no need of mediation, I think.
I don't know. I don't. Yeah.
As
You can say whatever you want to.
If she gives her,
You can say whatever you want to. I can't write whatever you say.
Lord say I call physically present.
No, not physical presence will not do. There has to be a mediation and there has to be a proper proceeding drawn.
wife may also be directed to be present in the court.
No, we are not going to do the mediation. Mediation will be done in Jharkhand.
Both have filed the joint compromise.
You are from local, one is from Khurti. The learned counsel for the parties are present. Counsel for the petitioner submits that the opposite party number 2 wife is living with the petitioner for last 2 years and they have amicably settled their dispute. The counsel for the opposite party number 2 submits that he has got no instructions in this regard. He has also submitted that if that be so, then appropriate petition is required to be filed and the matter can be sent for mediation. He submits that the matter be posted tomorrow so that he may seek instructions. Post tomorrow. Be sure of it.
Yeah.
2 years he has said.
No, he is saying, I'm not having any instruction.
We have got the instructions, he is present in the court, husband is present.
Let me check it.
Yes, you can, why not?
Not even one affidavit filed over here. And you are speaking
Today-
on the
today-
instructions of a person who is already convicted.
Today itself he has given instructions.
Let's see.
Item 8, Criminal Division 42 of 2022.
Petitioner. Yes?
I was paying for 2 weeks' time.
For what?
Final preparation for this final
What
year.
preparation?
The paper book is also not ready.
Nothing. No, you don't need a paper book for a revision application. What do you want?
Small indulgence, 2 weeks.
2 weeks. I can't give you 2 weeks. The matter is otherwise ready.
Because he has recently, 2-3 months back, his conviction or assessment. He
So you
was
want to
given rapid
enjoy?
bail. There was suspension of
You
sentence.
see, I cannot say that this court is not in a position to take up the matter.
No, Your Worship, I was paying this test.
So bail is, you see, bail is only till the pendency of this
Go
case.
through the depositions and all everything. That's why I was there.
LCR आया है इसमें?
LCR has been received. There is one more person who has been convicted. He's also filed a revision before this one.
What is the number? देखिए इस केस से दो.
That is not tagged in this case.
Tell me the
I'll
number.
just get the number. There's one order like this. 2 people were convicted in this case. 256 is the other.
256.
Yes.
Okay.
The both may be heard together.
Counsel for the petitioner is present. Nobody appears on behalf of the opposite party. Counsel for the petitioner submits that arising out of the same impugned order, another criminal revision being criminal revision number 256 of 2022 has been filed. He submits that both the matters be tagged,
Will be heard.
may be heard together. Considering the submissions post criminal revision number 256 of 2022 and also the present case on next Friday. At this, counsel for the petitioner has submitted that he does not have a copy of the records, LCR.
No, I have to prepare for final year.
Then you prepare.
Yes.
It's very simple. Next Friday.
Lordship, I was praying for 1st of March.
No.
Because I am not available next week. That's
No,
why.
no, no.
I have to go
Choose
out.
your day on the next week. I've given you the last day.
Thursday will be fine.
Thursday, okay. Post it on Thursday.
Item 9, criminal division 56 of 2022.
Yes, petitioner.
Under conviction under section 279, 337 and 304 of the A of the Indian Penal Code. Tempo accident was taking place, Your Lordship. And informant is a passenger, Your Lordship. Got injured, Your Lordship. However, I have not seen the LCR, Your Lordship. But what appears from the impugned order, Your Lordship?
I don't know. If you want to argue, argue. We do not know. There are concurrent findings. Concurrent findings. Are there concurrent findings?
Concurrent.
So you have to show the perversity. What is the perversity? $279, 3 months, 337, 2 years.
And 3048.
No, 3 months for 279, 3 months for 337, and 2 years for 304A. So,
Your Lordship.
how much time have you remained in custody?
1 year.
1 year have already remained in custody.
Your Lordship, may kindly see what is the prosecution case, Your Lordship, and what are the witnesses are saying, Your Lordship.
I'll see the prosecution case. What is your case? Death has happened?
Your Lordship,
There's no doubt on
death
that?
of one of the passenger happened, Your Lordship, but
You were the driver in the same vehicle?
Your Lordship, I'm driver in the same vehicle, Your Lordship. But Your Lordship, there are several contradictions regarding date of accident, Your Lordship, Your Lordship, no independent witness has been examined, Your Lordship. No other passengers who were traveling in the tempo, Your Lordship. No one was examined,
You
Your
just
Lordship,
tell
except
us.
the informant.
You just tell us.
Your Lordship.
Death is in dispute? No.
Your
Accident is in dispute? No.
Accident is in dispute, Your Lordship. Accident is in, because, Your Lordship, IU
It's
has
yes.
taken charge of the case after 10 days of the occurrence, Your Lordship. After 9 to 10 days of the occurrence, Your Lordship. I have not seen the LCR, Your Lordship, because in lunchtime I have asked for the LCR, Your Lordship, because, Your Lordship
Who
has,
did you ask and who did not give you the LCA?
Your Lordship, actually, Your Lordship has risen late, that's why they were in hurry, Your Lordship, and one other matter was also there in foot
It is
number
almost
13,
4
Your Lordship.
o'clock. So you
Your
see, you
Lordship.
can't say. Don't put the
Otherwise, Your Lordship, I
don't
did,
put
Your
the
Lordship.
blame on
Your
the
Lordship,
staff.
rising late, Your Lordship. That's why.
So you cannot say that you were asking them and they were not providing. They have a standing instruction that everything is to be provided to
Your
all
Lordship,
the
but they were in
advocates.
hurry, Your Lordship. They told to come at after the lunch
We
period, Your
resumed
Lordship.
the court
But
at 2:15.
I was on another court, Your Lordship. That's why I could not come, Your Lordship.
Counsel for the parties are present. Counsel for the petitioner seeks adjournment by stating that she has not gone through the impugned order from the gone through the lower court records. Pose this case under the heading of final disposal on next Thursday. Thursday को 2 केस, एक वो वाला, एक ये वाला, उसको भी फाइनल डिस्पोजल में डाल दीजिए. नेक्स्ट डे में नहीं मिलेगा टाइम. एंड दिस LCR
2:15 में ही ना होगा, Your Lordship.
2:15.
ठीक है, Your Lordship, देख लेंगे.
सवा 2 मुझे कर देंगे. 2:15 का कर दीजिए. हाँ पास हो गया उसको लिखा है
Paso case from daily list at 10:30, item 9.
Heard the learned counsel for the parties. This writ petition was earlier dismissed by judgment dated 7/3/2022. Absolutely. This writ petition has been filed for the following relief. This writ petition was earlier dismissed by judgment dated 7/3/2022. Against which the petitioner preferred appeal, being LPA number 152 of 2022. At the appellate stage, the petitioner had filed amendment being IA number 2554 of 2023. This was on account of the fact that the petitioner in the original writ petition did not take a plea about non-compliance of principles of natural justice, in the sense that he was never granted any opportunity to cross-examine the witnesses had not the petitioner it was argued by the counsel for the petitioner before the learned appellate court that they would argue their matter to the limited aspect regarding non-compliance of principles of natural justice, and it was submitted that the writ court did not consider the question of non-compliance of principles of natural justice in the departmental proceeding, as it was not pleaded in the writ application. Consequently, the petition for the amendment was filed at the appellate stage to incorporate the question of non-compliance of principles of natural justice, which according to the Honorable Division Bench was a very important aspect to be considered, as it was stated that the witnesses were examined in presence of the petitioner, but he was never allowed to cross-examine the witnesses. On account of amendment allowed in the writ petition at the appellate stage, the order passed by the writ court in WPS number 4956 of 2015 dated 7/3/2022 was set aside, and the matter was remanded back to this court for reconsideration after amendment. The order dated 17/5/2023 passed in LPA number 152 of 2022 is quoted as under. Pursuant to order dated 17/5/2023 passed in the aforesaid LPA, an amended writ petition was filed and by order dated 28/8/2023, the respondents were to file a counter affidavit to the amended writ petition. Consequently, a counter affidavit to the amended writ petition has been filed and a rejoinder has also been filed. As per the amendment sought for in terms of order dated 17/5/2023 passed in LPA number 152 of 2022, the following points has been added. Para 27 ka A and B. The learned counsel for the petitioner has confined his arguments on the point of violation of principles of natural justice, and additionally he has submitted that since the alleged incident had taken place when the petitioner was mentally unfit, therefore a sympathetic view may be taken by this court. Is that correct, Mr. Manji? These are the 2 points you have said. The learned counsel for the petitioner has submitted that the alleged incident regarding firing of 11 rounds had taken place in view of the fact that the petitioner was given continuous duty, and the petitioner was due to which the petitioner was mentally unstable and therefore the reason for such filing cannot be totally attributable to the petitioner. The Learned Counsel has also submitted that though there was firing of 11 round, but neither any person was injured, but no person was injured, and there has been no loss of any life or property on account of the action of the petitioner. The Learned Counsel has submitted that on 2/3/2014, the 3 witnesses were examined. But during inquiry proceeding, the inquiry officer had not given option either to the petitioner or his co-employee to cross-examine the witnesses produced in support of the charges. He has also stated that the petitioner was asked to sign on typed copy of the statement of the witnesses of the department, and a threatening was given by the inquiry officer that if he will cross-examine the PWs, then he will be dismissed earlier from the service. It is the case of the petitioner that on account of such mental pressure on the petitioner by the inquiry officer, on account of the mental pressure on the petitioner, the inquiry officer had taken signature of the petitioner in typed statement of PWs. And that the inquiry officer had also not given any opportunity to the petitioner to produce defense witnesses, and therefore the entire inquiry proceeding was conducted in violation of the principles of natural justice. During the course of hearing of this case, and upon a specific query made by this court, the Learned Counsel has placed the reply filed to the second show cause as contained in Annexure 10 to the amended writ petition, and has referred to internal page 2 of the said reply, wherein the petitioner had stated that the inquiry officer had only taken the evidence of the PWs, but had not taken the evidence of two other persons, namely Shri Vijay Kumar Singh and Shri Shankar Uraon, who were eyewitnesses to the incident. And the persons who were present at the time of occurrence would have substantiated that the petitioner was innocent. The Learned Counsel has fairly submitted that the plea that has been taken, the aforesaid plea which has been introduced by way of amendment was not taken in the second show cause reply filed by the petitioner as contained in Annexure 10. And during the course of hearing also, no such statement from the second show cause reply has been pointed out to the court. Is that correct? The Learned Counsel has also placed the memorandum of appeal which was filed before the appellate authority and has been annexed along with the counter affidavit filed by the respondents at page number 89 and which was filed on 18/2/2015, and while placing the same also, the Learned Counsel has not been able to point out any such plea which has been argued by the petitioner while challenging the impugned action on the grounds of principles of natural justice so far as the order passed by the disciplinary authority is concerned. However, the Learned Counsel has referred to the additional memo of appeal which was filed before the appellate authority as contained in Annexure 12, which was filed on 4/3/2015, and from the said memo of appeal, the Learned Counsel has referred to paragraph 15 and 16 and has submitted that the plea which has been raised in the writ petition has been raised before the appellate authority on 4/3/2015. The Learned Counsel submits that such plea was raised before the appellate authority. Still, the appellate authority has dismissed the appeal and has passed a punishment of removal from service. The learned counsel submits that on account of violation of principles of natural justice, as has been placed on record through the amendment petition, the impugned order passed by the disciplinary authority calls for interference. Have I left anything?
Madam,
No argument has been left out?
sympathetically, consider
The learned counsel has also submitted that
lesser punishment.
a sympathetic view may be taken and the petitioner be given lesser punishment. The petitioner is of young age
35
and
years.
is only 35 years of age, and therefore considering the totality of the circumstances, the impugned order of punishment be set aside. That's it.
Punishment
Be set aside.
It is 39 years, Your Lordship, in the cost title.
39 years.
No, no,
You have stated 39 years.
date of birth, according to certificate.
Party position may be seen.
You have stated 39 years in your affidavit. Right? 39 years later. The learned counsel appearing on behalf of the respondents, on the other hand, has submitted that a detailed counter affidavit has been filed in the present case, and the statement of the witnesses
Page number 60.
have also been placed on record. He has referred to annexure J series of the counter affidavit and has submitted that the petitioner had duly put his signature on the same. The learned counsel has also referred to the final statement which was given by the petitioner before the inquiry officer at annexure L/1, wherein the petitioner has stated that whatever he had stated in his initial show cause reply, he does not have any further to say. The learned counsel has submitted that even at this stage before the inquiry officer, no grievance was raised by the petitioner.
Objection.
No grievance or objection was raised by the petitioner, and the learned counsel submits that the allegation made by the petitioner against the inquiry officer that he had coerced the petitioner to put certain signature and had threatened the petitioner is not born out of the records of the inquiry proceedings, or no such grievance was ever raised by the petitioner before the disciplinary authority while filing his second show cause reply, nor such plea was raised in his initial memo of appeal, and such plea was raised for the first time only while filing the additional memo of appeal, which is apparently an afterthought. The Learned Counsel has submitted that the scope of interference in the matter of disciplinary proceeding is very limited. He has also submitted that the incident is not in dispute, and it is the case of the petitioner that on account of mental imbalance, such incident had happened. The counsel submits that firing of 11 round without any reason cannot be lightly taken, and the order of punishment of removal from service does not call for any interference. The petitioner is not fit to continue in disciplinary force.
Even the firearms was inspected, Your Lordship, annexed due to the counter.
The incident is not in dispute. Is that correct? Incident is not in dispute. The Learned Counsel has also referred to page 68 of the counter affidavit, wherein what is the name of the petitioner?
Vishwanath Manji.
Vishwanath Manji. That may not be required. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court finds that the argument of the petitioner is confined to violation of the principles of natural justice. It is the specific case of the petitioner through the amended writ petition that the petitioner was present at the time of evidence of 3 witnesses, and typed copy of the witnesses were produced before him and he was asked to sign on them. And he was threatened, and he was told that he will not be permitted to cross-examine any of the witnesses, and he was threatened that if he would cross-examine any of the witnesses, he will be dismissed from service. This court finds that it is not in dispute that the petitioner was a police constable, and at the relevant point of time he was posted at Pokhriar Picket Tundi, PS Dhanbad. It was alleged that the petitioner made 11 round fire in air at about 5 p.m. on 29/7/2013 from his AK-47 rifle in his room and outside his room, and upon hearing such firing, the unit in charge and other constables caught hold of him and took him to Dhanbad police station. And upon observation, it was recorded that the petitioner had lost his mental balance. It is further not in dispute that the petitioner was charge sheeted and suspended from his service by the office order dated 19/12/2013, and charge was framed against the petitioner. The allotted arms were examined by expert on 3/10/2013, and on the basis of the report dated 20/10/2013, a departmental proceeding was proposed against the petitioner, and the petitioner was charge sheeted by memo number 5148 dated 28/12/2013 and was directed to file his show cause. In the memo dated 28/12/2013 itself, various exhibits and witnesses from the side of the department were mentioned. Para 12. It was in the reply, in the reply to the memo of charge, the petitioner, which was filed by the petitioner on 3/1/2014 and annexed as Annexure 6 to the writ petition, it is apparent that the incident was not in dispute. The petitioner has tried to explain the circumstances under which he had fired 11 rounds. It was his explanation that he was under physical and mental tension for 2 to 3 weeks, and he was suffering from insomnia, in as much as he was not able to sleep at night. He was also aggrieved by the fact that at times the duty was from 10 p.m. to 12 midnight, 12 midnight to 2 a.m. and at times from 2 a.m. to 4 a.m., which was also a reason for his sleeplessness. Due to his sleeplessness, he was not even feeling hungry, and this state of affairs continued for quite some time. On 29/7/2013, he was having headache and lost his senses, and suddenly he found himself outside the police headquarters in Dhanbad, and thereafter he does not know what happened. Then thereafter he found himself in mental hospital at Rinpas, and ultimately he was found, and ultimately after being treated, he became fit for duty. The petitioner also explained that so far as the incident of 29/7/2013 is concerned, he was at the picket with AK-47, where he had fired 11 rounds in his room and outside the room. He has also stated that Mangra Uraon had heard the firing, and he with his other associates had taken control of the petitioner. The petitioner had stated that the entire incident had taken place due to his mental imbalance, and the petitioner, having regained his mental health, insisted that the order of suspension be set aside and he be taken back in service. However, the inquiry proceeding had taken place in connection with the charges of firing of 11 rounds. The petitioner duly participated in the inquiry proceedings. It appears that the statement of 3 witnesses were handed over to the petitioner, in which the petitioner had also put his signature. It further appears that it appears that statement of 3 witnesses was taken, though it was typed, and a copy was also handed over, and it was typed and a copy was also handed over to the petitioner. It further appears from the records of this case that the petitioner was also granted an opportunity to give his final statement before the inquiry officer, and before the inquiry officer, the petitioner clearly stated that he has nothing to say in his defense except what has already been stated in his show cause reply, in his first show cause reply. And ultimately, a second show cause was issued to the petitioner, to which the petitioner duly responded by letter dated 18/11/2014. In the second show cause reply, the grievance of the petitioner was that the inquiry officer had taken the evidence of only those persons who had deposed to hold him guilty, but the evidence of other persons like Vijay Kumar Singh and Shri Shankar Urao, who were present in the place of occurrence, was not taken. Who would have held the petitioner innocent? The petitioner also stated that in view of the judgment passed by High Court, at least in order to hold a person guilty, there should be at least 2 witnesses, and the witness of the complainant could not have been taken into consideration for holding him guilty. The stand of the petitioner, as mentioned, the approaches stand of the petitioner as mentioned in second show cause notice is quoted as under page number 40 का bottom में इसको ले लीजिए. It was also the case of the petitioner in the second show cause notice that on account of his unfitness and both physical and mental, the petitioner having fired suddenly from his AK-47 is not a serious offense so as to dismiss a person from service. Such stand was taken by the petitioner in internal page 3 as under. ये पूरा ही कोट कर दीजिए, संचालन पदाधिकारी से यहाँ तक 41 तक, right, and then 42 also. This court finds that in his second show cause reply, the grievance of the petitioner that he was not given any opportunity to cross-examine, or that he was not given any opportunity to lead his defense evidence, or that the inquiry officer had threatened him not to cross-examine the witnesses has not been taken, nor the records which has been produced by the respondents through their counter affidavit. There is any such indication. Rather, at the end of the examination of the witnesses, the petitioner was called upon to give his statement, to give his closing remarks, and then the petitioner had stated that he had nothing to say in the matter except what was already stated in his show cause reply. First show cause reply. The content of the aforesaid letter filed by the petitioner before the inquiry officer is quoted as under. Let's quote that also. Yes. After the consideration of his second show cause reply, the petitioner was removed from service.
Dismissed initially.
Was initially dismissed from service by the impugned order dated 25/1/2016, against which what was the order? By the order dated? 5/2/2015, against which the petitioner filed appeal. The initial memo of appeal has not been filed by the petitioner in his amended writ petition. However, the same has been brought on record by the respondents in their counter affidavit. upon perusal of the memo of appeal which was initially filed by the petitioner, no such grievance has been raised by the petitioner as has been alleged by the petitioner while through the amendment of the writ petition. Of course, the petitioner had filed additional memo of appeal, which has been filed by the petitioner along with the writ petition, and following points have been raised in paragraph number 15 and 16, which are as under. This court finds that the aforesaid 2 points as paragraph number 15 and 16 has been raised for the first time in the additional memo of appeal. This court also finds that the petitioner has made very serious allegations against the inquiry officer, that the inquiry officer had threatened the petitioner not to cross-examine the witnesses. Who was the inquiry officer? SP Dhanbad was the inquiry officer.
No, Your Lordship. He was.
And the inquiry officer is not even a party in the present proceedings. He is not a party. The inquiry officer is not even a party in the present proceedings. Who could have been the best person to respond to whatever the petitioner has stated? I'll see whether I would like to retain this or not. I'm not sure about it.
Inquiry officer was Police Nirakshak Sindri Anchal. Shrikant Upadhyay. At page number 74 of my account.
This court finds that at the stage of inquiry, the petitioner did not raise any grievance. The petitioner admittedly did not raise any grievance at the stage of demand or objection with regard to the manner in which the inquiry proceedings was conducted, nor he raised any objection regarding any kind of threatening given to him by the inquiry officer, nor he raised any such grievance before any other authority with regard to the alleged threatening given by the inquiry officer. Even in the second show cause, no such grievance was raised. Even in the initial memo of appeal, no such grievance was raised. It was only at the additional memo of appeal such grievance was raised by the petitioner for the first time. This court is of the considered view that such grievance which has been raised by the petitioner for the first time in the additional memo of appeal is apparently an afterthought.
In the appellate stage.
At the appellate stage, that too, at a later later stage before the appellate authority. This court is of the considered view that the scope of interference in the matter of disciplinary proceedings is very limited, and considering the aforesaid aspects of the matter, and also the fact that it is not in dispute that the incident had happened, and that it is the case of the petitioner that the incident had happened due to his mental imbalance, this court is of the considered, this court is not inclined to interfere with the impugned order of removal which has been ultimately passed by the appellate authority. This court is of the view that the punishment imposed upon the petitioner by the appellate authority is neither is adequate and is proportionate to the charges proved against the petitioner. Consequently, this court is not inclined to exercise powers under Article 226 of the Constitution of India in to set aside the punishment of removal as imposed by the petitioner by the appellate authority. I will cite certain judgments regarding the scope of 226 also. The state petition is accordingly dismissed. There will be corrections, right? There will be, but this is the gist of the order. I will cite a few judgments also in support of whatever reasons I have given. You have not brought those judgments, therefore I will have to